In less than 12 hours, legal minds will once again battle it out in court over the politically controversial BBI issue that has twice been declared illegal before the courts. The Supreme Court has issued its directions on how time will be shared and allocated between the applicants and the defendants, a matter that the Attorney General says is heavily skewed in favor of the respondents. Leila Mohammed has more details on that story.
The first time the seven-judge bench of the Supreme Court sat to listen to legal arguments over the matter was in late 2021, with one party raising in the application that 3 judges on the same bench recused themselves from hearing the Building Bridges Initiative case over perceived impartiality. The court threw out that application by Isaac Alu-Ochier, a member of the Citizens Voluntary Group opposed to the BBI, saying that his statement was speculative and there was no evidence to support the same.
The applicant having instituted his petition against the judges to the Judicial Service Commission, the same should be allowed to take its course, as the Judicial Service Commission is an independent constitutional body and operates separately from this court.
In the ruling read by Deputy Chief Justice Philomena Mwilu, the court also premised its decision on the doctrine of necessity to have the case heard by the full bench of 7 judges owing to the public interest. Come Tuesday, January 18th, the 7 judges will begin hearing submissions from the state and the defendants who are at the initial stage, while the applicants whose case sailed through at the High Court level.
Honorable Chief Justice.
Hours before the court begins to hear oral arguments, the appellants and former petitioners have been allocated 45 minutes each, with other respondents being allocated 15 minutes. But in a letter to the Registrar of the Supreme Court, the Attorney General has registered his concerns with the directions by the court, stating that the time allocation is skewed in favor of the respondents. The AG notes that his team will be addressing weighty matters of great public importance. He goes ahead to state that whilst each party has been limited to written submissions of only 28 pages, it is necessary, however, that the parties and in particular the Attorney General be granted reasonable time to address and elaborate on the issues raised in the appeal in order to assist the court in arriving at a just determination of the critical matters that the court has been called upon to resolve. The AG proposes that all parties be allocated at least 6 hours to be shared among them, or the first appellant be allocated an additional 1 hour and 45 minutes. As the registrar figures out the logistics to enable each party argue their case, the AG and his legal team will be armed to fight one last time to get the court on board with the President's vision that was quashed in May 2021 when the High Court declared a huge section of the BBI document illegal. In that sitting, the High Court bench noted among 14 other issues and issued a declaration that at the time of the launch of the Constitution Amendment Bill 2020 and collection of endorsement signatures, there was no legislation governing collection, presentation and verification of the signatures, nor a legal framework to govern the conduct of a referendum. The judges also declared that the entire constitutional change process promoted by the BBI committee is unconstitutional, null and void. They also stated that the Constitutional Amendment Bill 2020 cannot be subjected to a referendum before the IEBC conducts a nationwide voter registration.
Right, Mr. Ngawa, you are...
Once the case was brought before the Court of Appeal, the judges there gave an order to the IEBC, restraining it from undertaking any processes required under Article 257(4) and 5 in respect of the Constitution of Kenya Amendment Bill 2020. They also argued that President Uhuru Kenyatta had contravened Chapter 6 of the Constitution and specifically Article 73(1)(ai) by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of that very Constitution. They further argued that county assemblies and parliament cannot, as part of their constitutional mandate, change the contents of the Constitution of Kenya Amendment Bill 2020, initiated through a popular initiative under Article 257 of the Constitution. Leila Mohammed, NTV.